I invite Safi sir for the rest of the session. Over to you, sir.
So, we can discuss the judgment in different perspective. For example, we can discuss this judgment on the basis of its political perspective and ethical perspective and in the constitutional perspective. We are discussing this judgment purely on the constitutional perspective. As you know that Manisha, next slide. This case came in front of the Supreme Court under its writ jurisdiction under Article 32 of the Constitution. You know that the allowments are already explained the relevancy of the case. And I just inform one particular matter itself, that it was the Annual Financial Act 2017. It was in that particular act, the electoral bond scheme was introduced by the then Finance Minister Arun Jaitley. And in that Finance Act, some of the important statutes were amended, including the Reserve Bank of India Act of 1934, the Representation of Peoples Act of 1951, the Income Tax Act of 1961, and the Companies Act of 2013. So I think law amendments are already explained the relevancy of all these amendments. So, the most important question before the court was, can you take the next slide? Was that the two important constitutional, the most important part of the discussion is the constitutional power of two important institutions: the Honorable Supreme Court of India under Article 32 of the Constitution, and the power of the constitutional power of the Parliament to make legislations, and what about the constitutional validity of the legislations enacted by the Parliament and amended by the Parliament. Here, what the Parliament did, the Parliament amended so many statutes, some post-constitutional legislations and pre-constitutional legislations, like Reserve Bank of India Act of 1934 is actually a pre-constitutional legislation, and the rest of the statutes are the post-constitutional legislation. So, the question in front of the court was under Article 32 was whether the court has the power to entertain this particular issue in front of the court under Article 32 of the Constitution. So there are in two ways a court under Article 32, the Supreme Court of India, under Article 32 of the Constitution can entertain a writ petition. For example, in the first case, if there is any violation of the fundamental rights, if the statute is violative of the fundamental rights. And secondly, whether the institutions are competent to make such kind of legislation. Doesn't matter whether the statute is against the fundamental rights or not, but the legislative competency is also a very important question. Here, the legislative competency is not a question, but at the same time, the question is, can you take the next slide? The question is the violation of what extent these amendments made in many statutes violates fundamental rights. Allowments are already mentioned. Two articles were questioned in front of the Honorable Supreme Court. The first article is Article 14, and the second article is Article 19 of the Constitution. So, and also a very important point, at what extent the democratic values of the Constitution was safeguarded in this amendment, what extent the democratic values of the Constitution is protected under this amendment. So I would like to mention one of the most important judgment of the Honorable Supreme Court delivered in 1977. This judgment was delivered by Justice V.R. Krishnaiah and Vittal Nagaraj versus Dayanand Sagar in this judgment. This is a very classical judgment. In this judgment, the court held that. Now first we are discussing about the democratic values of the society. on the basis of pure legal analysis, where Justice V.R. Krishna said that the candidate often evade the legal ceilings of the expenditure by using big money channelized by political parties. The large monetary input are necessary evil of modern elections, which would be eradicated sooner or rather than later. So this is actually the judgment of the legendary judge Justice V.R. Krishna in 1977. So what was the then happened? Another judgment. Can you take the next slide? That case was reported in 1996, and that case was Common Clause, a registered society versus Union of India. This was a constitution. In this case, Justice Kuldeep Singh. This is a classical judgment, where the court held that the general election is a numerous exercise and a mammoth venture in terms of money spent. Hundreds and thousands of vehicles of various kinds are pressed on the road, and in 254 parliamentary constituencies on behalf of the thousands of aspirations to power. Millions of leaflets and many millions of posters are printed and distributed and posted all over the country. Banners by the lakhs are hoisted and flag go up, walls are painted, and hundreds of thousands of loudspeakers play out loud, extravagant promises. And please, next slide. In the same judgment, Justice Kuldeep Singh said, VIPs and VVIPs comes and go, then in helicopters and air taxis. The political parties in their quest for power spend more than 1,000 crores of rupees on the general election. This case was reported in 1996. And Justice Kuldeep Singh mentioned about 1,000 crores rupees in this judgment, and yet nobody accounts for the bulk of the money so spent, and there is no accountability anywhere. Nobody discloses the source of the money. There are no power. There are no proper accounts and no audit. From where does the money comes from? Nobody knows. In a democracy where rule of law prevails, this naked display of black money by violating the mandatory provisions of law cannot be permitted. So this is a classical second important judgment which is mentioned in the current judgment. So the Kuldeep Singh's statement, as mentioned in this judgment, is so relevant as far as the present judgment is concerned. So can you take the next slide? So democracy. The India is the largest democracy in the world, and democratic form of government is one of the basic structure of the Indian Constitution. So it was so first held in the Keshavananda Bharati versus State of Kerala case, 1973, where the Honorable Supreme Court held that republican and democratic form of government form the basic element of the constitutional structure. And in 2 years after, in 1975, the Honorable Supreme Court held that that case was Indira Nehru Gandhi versus Narayan. Justice H.R. Khanna reiterated that the democratic set of government is a part of the basic feature of the Constitution. So the earlier two judgments and these present judgments and also the other judgments, can you take the next slide? The two other judgments in the Kuldeep Nair versus Union of India 2006 judgment. In that constitutional court judgment, the Honorable Supreme Court held that a democratic form of government depends on a free and fair election system. And the People's Union for Civil Liberties versus Union of India 2013 judgment, the court held that free and fair election denotes equal opportunities to all people. So I explained 6 important judgments where we could understand the democratic values of the Constitution, and these 6 judgments are clearly mentioned in the present judgment. So the question in front of the court was whether these amendments made by the BJP government is inconsistent with the fundamental democratic principles as laid down in the Indian Constitution, and also whether that amendments were inconsistent with the earlier judgments of the Honorable Supreme Court. That is the first issue. The second issue was because of different reasons. Because I just explained what are the fundamental things happen in the present amendment, which Lowell Menser didn't mention. The electoral, the issue of bond is actually the monopoly of, it was the monopoly of the RBI, and in this amendment, by way of this amendment, the central government take away this power from the RBI, and by way of this amendment, the central government gave the same power to the State Bank of India. The first thing. And second thing is, before 2007, only the profit-making companies are eligible for granting donation to political parties. But at the same time, after this amendment, loss-making companies can also can contribute money to the political parties. And also, before this amendment, only limited amount can be granted as a contribution. But at the same time, after this amendment, unlimited amount can be subject matter of the contribution, as already Lowell mentioned that the bond size is from 1,000 rupees to 1 crore rupees. And before these amendments, the Indian company are only eligible for the contribution, but after the amendment, the foreign companies are also eligible for the amendments. And all these are mentioned in page numbers 161 to 233 of the present judgment, because we are discussing two important judgments. The first judgment is the earlier judgment, and the second judgment is a judgment delivered by the Honorable Supreme Court in its contempt jurisdiction, that is SBI versus the Association of Democratic Reforms. So these two judgments are also very relevant as far as the discussion is concerned. And also, before 2017, only with the consent of the shareholders and the board of directors, a company can make contributions. But after the amendment, without the consent of the board of directors and without the consent of the shareholders, they can do that. And this is also that this contribution, the company will not get any benefit because it is a quid pro quo transaction, and these bonds are not tradable. These bonds are not transferable. These bonds are non-refundable also, as Lowell Menser already mentioned. And also the lifetime of this bond is 15 days. And very important point is that if after this 15 days the political party, if the political party is not redeemed the bond, then the amount, then that amount is vested in the PM care fund. And interesting thing is that is also not subject matter of the Right to Information Act. So you will not get any information from the PM care fund what extent of money which is there in the PM care fund from these bonds. And also, so the very important point is that this amendment is not within the purview of the Right to Information Act, and the transactions which are not come under any transaction, whether it comes in the hands of the political parties or whether it comes in the hands of the PM care fund, this is not subject to the Right to Information Act. So the secrecy is the main reason why the cases came in front of the Supreme Court. And also, that there was a warning from the Reserve Bank of India dated 27 September 2017, and after a committee meeting of the Reserve Bank of India, expert committee meeting of the Reserve Bank of India, and the Reserve Bank of India sent a warning letter to the central government stating that these amendments will definitely encourage money laundering. That is the first point. And the second point is that in 26th May 2007, the Election Commission of India, you know that Election Commission of India is actually a constitutional institution, and they also send a warning to the central government stating that these amendments will definitely affect the fair and independent democratic process, because secret unlimited corporate funding will affect the more encouragement for the shell companies, because a loss-making company can also make a contribution to the political party. Therefore, it will definitely encourage shell companies in India. Therefore, this will definitely affect the fair and independent election process of our country. So they have to take proper care and caution. But these two important reports were ignored by the central government: the report of the Reserve Bank of India and the report of the Election Commission. So that is the one of the major reason why the case came in front of the Supreme Court, and the most important question was whether the amendments is violative of the democratic values of the Constitution first, and second thing is whether it is a violative of rule of law. Because the rule of law is something which is very essential thing, because the question is whether these amendments there is absence of fairness. The first important point, the absence of fairness, and second one is whether these amendments are manifestly arbitrary. That is a very important question. It is whether it is manifestly arbitrary, because of the reason that maintaining secrecy of donors who donates money to the political party is violative of the right to know. That is the second question. So can you take the next slide? So so first of all, Article 19 of the Constitution. The first case was in 1975, the state of UP versus Rajnarayan. In this case, the court held the right to information is part and parcel of Article 19 Clause 1A of the Constitution, the first important case. And then three important judgments as mentioned in the judgments: SP Gupta versus Union of India, 1981 case; Union of India versus Association of Democratic Reforms, 2002 case; the PUCL versus Union of India, 2003 case. In this case, the court reiterated the importance of right to know, the right to information of the voters. Because of this judgment, you know that there was lot of information of the candidate is available now because of this judgment. For example, the criminal part of the accused, educational qualification of the accused, the assets and liabilities of the accused, including the assets and liabilities of the spouses of the accused, and also their competency, their capacity, their suitability, everything is known to the authors, not because of the Representation of People's Act, but because of these three important judgments: SP Gupta versus Union of India, Union of India versus Association of Democratic Reforms, and UPCL versus Union of India judgment. So this is a very important point. So first of all, as a citizen of India, as per the state of UP versus Rajnarayan, we have the right to information, because right to information is an essential part of Article 19 Clause 1A, and 19 Clause 1A of the Indian Constitution is the heart and soul of democracy. And then on the basis of these three judgments, these right to information, the right to information about the candidate on various aspects is essentially part of Article 19 Clause 1A of the Constitution. So the important question was what extent the central government can make restriction on the freedom of speech and expression and the right to information. So those restrictions which are mentioned in Article 19 Clause 2. As you know that Article 19 Clause 2. 19 Clause 2 imposes certain restrictions on 8 grounds. Eight grounds are mentioned in Article 19, Clause 2. On that 8 grounds, the state can make reasonable restrictions. So the ground mentioned by the government is actually the interest, the general interest of the interest of the general public. That was the ground mentioned by the central government, which was mentioned by the Solicitor General in the Supreme Court, that the ground that they are trusted for amending all these provisions is public, the general interest of the public. It is public interest. But the interesting aspect is that public interest is no longer a ground which is mentioned in 19 Clause 2 of the Constitution. So the central government has no right to restrict the freedom of information by using the ground as mentioned by the Solicitor General in the Supreme Court. So that is a very interesting point. That is also relevant. So then, thus, these amendments violate Article 19 of the Constitution. So first of all, these amendments violate the democratic values of the Constitution. Secondly, because of these judgments, the amendments violates Article 19 of the Constitution, because Article 19 of the Constitution and the democratic values of the Constitution are the basic structure of the Constitution. The democratic values of the Constitutions are the basic structure of the Constitution. It was so held in the Keshavananda Bharati versus State of Kerala, and Indira Nehru Gandhi versus Rajnarayan, and also Article 19 in number of judgments, the Honorable Supreme Court held that in SP Gupta versus Union of India case also, the Article 19 of the Constitution is the basic structure of the Indian Constitution. So then the next question is that the last point. The last one. Can you take the next slide? Yes. So Article 14. Article 14, as you know that Article 14 is the rule of law, and Article 14 is that which is one of the basic structure of the Indian Constitution. And based on all these judgments are mentioned by the Honorable Supreme Court in the same judgment itself, starting from 1951 judgment, the state of West Bengal versus Anwar Ali Sarkar, to the last judgment, Joseph Shine versus Union of India judgment, 2019 judgment. So in the first judgment, the Honorable Supreme Court held that in order to evoke Article 14 of the Constitution, we have to look into an intelligible differential and rational nexus. That is a very important point. So in this case, that there is a lack of intelligible differential and rational nexus with respect to all these amendments are concerned. And second point is that in EP Royappa versus State of Tamil Nadu, that case was reported in 1974. In that case, the court clearly explained what is arbitrariness, and that arbitrariness is there in these judgments, because these amendments are actually arbitrary in nature. Therefore, it violates the EP Royappa versus State of Tamil Nadu judgment, because all these judgments are law of the land by virtue of Article 141 and Article 142 of the Constitution. So what about Menaga Gandhi versus Union of India? As you know that the Menaga Gandhi versus Union of India is the judgment of the Constitutional Bench of the Honorable Supreme Court in 1978. And in that case, the Honorable Supreme Court held that the procedure established by law must be just, fair, and reasonable. So here, the procedure established by law is not just, fair, and reasonable. These amendments were not just, fair, and reasonable. It is manifestly unjust, and it is manifestly arbitrary. That is the main important findings of the Honorable Supreme Court. And also in Ajay Hasia versus Khalid Muji's case, the Honorable Supreme Court held that not only in legislative actions but also in the executive actions, if there is any arbitrariness, and then it is violative of Article 14 of the Constitution. So that is a very important. And in 2017 judgment, already Lowellments are mentioned in Shaira Banu versus Union of India judgment, where the Honorable Supreme Court declared Mutalaq as unconstitutional. because of the reason that it is manifestly arbitrary. The provision is itself manifestly arbitrary. Talaq il bidat, the mutalaq is arbitrarily manifest. And in the next year, in 2018, in Navjot Singh Johar case, the Union of India case in 2018, the Honorable Supreme Court held that Section 377 of IPC is violative of Article 14 of the Indian Constitution. It is manifestly arbitrary. The provisions is manifestly arbitrary. So this is repeated in these three judgments, in Shaira Banu's case, Navjot Singh case, and also in Joseph Shine case. As law elements are already mentioned that in Joseph Shine's case, the Honorable Supreme Court in 2019, the Justice Nariman specifically mentioned the fact that the Section 497 of Indian Penal Code is manifestly arbitrary. So, citing the judgment, the state of West Bengal versus Anwar Ali Sarkar, to the Joseph Shine versus Union of India, the Honorable Supreme Court unanimously declared that the legislation made by the central government with a bad intention, with a dishonest intention, is violative of Article 14 of the Constitution. So that is what the relevancy of these judgments. Therefore, these amendments were violative of the democratic values of the Constitution first. Second, it is violative of Article 19 of Indian Constitution and the freedom of information of the authors, and also the Article 14 of the Indian Constitution, because it is manifestly arbitrary and unjust. All the amendments were manifestly arbitrary and unjust. Let me conclude my presentation. At the same time, I would like to say that we have to appreciate some institutions and some political parties, and also lawyers who appeared on behalf of the petitioner in this case. First of all, I would like to, as a legal professional, it is our duty to appreciate those people who are standing for democratic values of this great nation and the constitutional values of this great nation. And in that respect, I would like to say that I would like to appreciate the decision taken by the 5 constitutional judge bench, including Justice Dr. Chandrachud, for deciding this case in such a fabulous manner. And secondly, I would like to appreciate the petitioners of this case, including the 3 petitioners: Association of Democratic Reforms and Common Clause, and also the Communist Party of India Marxist. Because the Communist Party of India Marxist is the petitioner of this particular case, and they are also a political party. But at the same time, the Communist Party of India Marxist and the Communist Party of India is the only political party that openly mention that they will never accept money by way of these bonds. So that is the reason why I would like to say that they are they actually these parties are trying to the non-governmental organization like Common Clause and Association of Democratic Reforms and also the parties like Communist Party of India Marxist. They did a tremendous job. And also I would like to extend I would like to mention some of the names who appear, lawyers who appear for this particular case, including Prashant Bhushan and Kapil Sibal. Because of their sincere effort, we had strengthened the democratic values of the Constitution. But at the same time, I have one reservation. I would like to say that, you know, that we had approached this case in front of the Honorable Supreme Court by using its writ jurisdiction under Article 32 of the Constitution. And you know that writ jurisdiction, we have an information that writ jurisdiction is the most speedy remedy of the Honorable Supreme Court. But at the same time, the case was filed in 2017 and the decision came in 2024. 2024 in February. So it took almost 7 years. It is something which we could rightly say that justice delayed would amount to justice denied. And unfortunately, in many of the recent cases, when you look into many of the recent cases, the serious violation of fundamental right cases, we could understand that by using Article 32, the Supreme Court of India taking 5 years or 7 years for completing, for deciding some of the very vital cases. Because of lack of time, I am not mentioning any of the judgments, but this is actually unfortunately happening. It is because that is also a very concern. I would say that the Supreme Court is not evoking Article 130 of the Indian Constitution. That is one of the concerns that I would like to mention, because of the reason that Article 130 of the Indian Constitution specifically mentioning the fact that the Supreme Court can constitute circuit benches. So if the Supreme Court constitute any circuit benches, then we could definitely decide these particular cases very quickly, because you know that if such kind of matters be decided in a very quick manner, it will create very serious violations of human rights. Because of this delay for almost 7 years, the political parties looted almost 10,000 crores rupees from the ordinary people of this country. Because as you know that most of the case, public limited companies are main donors. You know that these public limited companies are, millions of shareholders are the owners of this public limited company, and they lost money because of that reason. So I would like to say that justice, especially like Article 32 is concerned, it should be always time bound. Therefore, we need such a mechanism whereby writ petition should be decided in a very time-bound manner. Even otherwise, there is a serious human rights violation. Thank you very much.